You are listening to the Justice in Heels podcast with me, your host, Danielle. Join me as I discuss interesting legal topics with inspiring female legal professionals who paved the way for the rest of us. Welcome to another episode of the Justice in Heels podcast. Today, I have Maryke van der Westhuizen with me. Maryke, thank you so much for joining me and welcome to the podcast.
Good morning, Danielle. Thank you for having me. I'm so excited, and I'm so excited with what you are doing with this Justice in Heels. May it just go from strength to strength. Thank you very much for having me.
Thank you. So, can you tell our listeners a bit more about yourself?
I was born in the Goldfields, Welkom, Free State area, normal childhood. After school, started working at firm of attorneys. I was only 27 when I realized law was my passion. Started studying through UNISA, some pitfalls, financial, going through divorce, so I had to stop for a while. But 2016, I just took the bull by the horn, graduated 2020, admitted 2022, and I'm now proud to be the owner, sole proprietor van the Westhuizen attorneys here in the Western area.
Oh, fantastic. So, today we are speaking about a very topic, which is wills. So let's start this conversation by asking Maryke, what are the requirements for a legal will?
Danielle, this is something that's quite interesting. First thing, it has to be in writing. In writing means handwritten, typed or printed. When it's handwritten, there's a possible pitfall that one of the heirs are not allowed to write that by hand. So grandma is wanting to make a will, granddaughter is doing the writing. If she's one of the beneficiaries in the will, they are looking at a problem. Person from the age of 16 years, they can start making their will. So if you don't want your sister to get your Xbox, then rather make a will and make sure your best friend gets it. We've got a lot of young entrepreneurs out there, starting with vegetable farming, small chicken coops, and even fixing bicycles. So even if you are young, if you want to make sure that business of yours has a future and you can identify someone that you think can go forward, make your will. You are never too young to start having a will. Also, when making a will, the basics is the testator or the testatrix, that's the person making the will, should sign each and every page. What we like to do, just being accepted, I have two witnesses co-sign on every page of the will, and I even go further. I have them put their names and their identity numbers, because there have been numerous court cases where the validity of a will is in dispute. Small things that causes that type of problem. You get people, they are not able to sign a signature, they have to sign with a cross mark or thumbprint. In that instance, it has to be done in the presence of a commissioner of oath. So, no, that's that. There's a court case also where the person typed his will on his computer, and then he left notes saying where his will could be found and everything. And that matter went to court. Okay, unfortunately, he committed suicide, but then the court held, okay, it was password protected. It can be assumed quite reasonably it's his will. They accepted it. But when dealing with wills, someone has to die, and the family goes through this very, very trying time now to be confronted with a will that's either not existent, that's not valid, or there are some disputes. So my advice is take the effort, make sure your will is drafted in a valid format, and that you make your wishes known, so that afterwards we don't get into unnecessary court battles where some of the heirs or people that didn't inherit anything disputed in court, and then more often than not that whole inheritance goes towards legal fees, unfortunately.
That's something that happens a lot, unfortunately. So who can actually draft a will? Can you like draft your own will? Does it have to be registered at court?
Nothing prohibits you from drafting your own will, but then again, is the person that's going to write that will going to be an heir? That's a pitfall. Are your signature going to be on every page? Is it going to be dated? Because a will that's not dated means nothing, because how can we prove that was in fact the last will and the last will and testament? Also, obtain advice pertaining to drafting your will. Are you leaving minded children behind in the event? Who's going to be the guardian? The funds that has to go to the children in the end, is it going to be a testamentary trust? Who's going to be your trustees? Or is it going to go into the guardian fund? So enacting a will in this day and age, don't try it at home. I unfortunately had a matter where husband and wife made an affidavit. That affidavit, firstly, I don't have the original affidavit. Secondly, no two independent witnesses. The only date stamp is the date of the police officer that commissioned the will, and unfortunately that will not be acceptable. So some of the broker firms, banks, and also lawyers assist with drafting of wills and giving advice, because to draft a will that's ill-advised, you're going to leave your heirs and the people that stayed behind with lots of tears if the proper thought and planning isn't taken into account when doing this will.
Definitely, I so agree with you. So before we started this recording, we just chatted and you told me about a few instances where some people didn't have a will and the consequences were dire. Can you share some of those stories with us without, of course, naming or giving names?
Just to put a scenario, you have the father, he's employed, he's got multiple properties, got some life policies, have a decent pension fund in place. Then he's married, so he drafts a will, 2-pager, everything goes to my wife. Nothing is stated about the minor child. So the wife, no one thinks about dying, no one wants to think about dying. During COVID, she passed away a week after the husband. No will in place, leaving behind a minor child. So, okay, then some of the family members came and they wanted to take the child to a new province, to a new school, where a new language is spoken, where they don't have the values in church going, everything would have been changing for that child. And what then had to happen is a curator at lighter matter be appointed, high court matter, costly. And then also at the end, a curator bonus had to be appointed to make sure the money is handled properly, and this girl is attended to until she reached the age of majority. So here we had a girl child, a minor, losing a father and a mother, don't know where the next piece of bread or the next bowl of porridge is going to come from, and then different family members fighting on who's going to lay claim on her father's money and what's going to happen to the houses and stuff. So if there was a joint will by the two parents, this would not have happened. And also, if the mother just made a will, 2 pages, something plain, then we could have known where's the girl supposed to go and what is supposed to happen to the immovable properties and the inheritance. Maybe the husband or the father had some other family members that he also wanted to benefit from his will. Or maybe the mother, okay, he wanted his wife to have everything, but maybe the mother, there could have been some verbal agreements just to make sure my mother is staying after, how it goes in a marriage. You talk about stuff, you don't put it on paper. So that is one instance. Another one, a lady, her husband died, no children. He had a motor vehicle under hire purchase, and she didn't think about everything. She just registered in section 18.3 estate. We'll get to that later on. And she was thinking, okay, I'm going to keep servicing the installments of the vehicle, And when the lump sum from the pension fund comes out, then I'm going to settle the car. And then what happened then when the bank realized that this guy has passed away and some time has lapsed and the lump sum hasn't paid out, they are repossessing a car. So now we are taking steps just to assist her. Another lady, just to make it short, husband died, married in community of property, no wills, and now children that he had from before his marriage, children that he hasn't seen for 20 years, odd years or so. Now that he's died interstate, now they want a cut of the estate. So that's all unnatural stuff. I mean, she has to deal now with her husband passing away, and that's a loss in itself. And now it's all these interfights and interaction. Everyone wants a piece of the estate, and all that it could have been not necessitated a will, even a 2-pager, nothing fancy.
So let's say, for example, now in terms of marriage, how does a marriage affect a will? So let's say, for example, you're married in community of property, or if you are married out of community of property.
In community of property, the day you put that ring around your husband's and wife's fingers, vice versa, I always explain it forms a circle. So the two of you are combined in that circle, assets, debts, part of the puzzle, few exclusivities like road accident claims and that type of things, but you see yourself as one bond in a ring. Now, if you're married in community of property and one of the spouses passes away, the whole estate in community of property is wound up. If with the community of property, 50% of the assets automatically goes then to the surviving spouse. And then the other 50% is dealt with either in terms of a will, or if the Interstate Succession Act comes into play, then we get child's portions, and a part of the child's portions, not less than 250, goes to the surviving spouse, and the rest to be divided. So this is also going without a will in community of property. Now we get to make some calculations. If there's a will in place, lots of this will not be necessary. Out of community of property, the assets are dealt with in terms of the will if there's a will in place. If there's not a will in place, and we look at the Interstate Succession Act, then we get spouse, children, grandchildren, huge spider's web that pans out.
So let's look at the other side. So let's say divorce. Why is it so important for someone who got a divorce to change their will, and how long do they have to change their will?
Our legal system accepts that in the case of a divorce, that the spouses need 3 months to change their will. So if the 3 months lapse and they don't do anything about the will and they pass on thereafter, then the court accepts, or the master accepts the fact that even though they were divorced, it was the intention that the ex-spouse still needs to inherit, or it's a wish that she or he still gets to inherit. So it's very important when you start your divorce procedures, or when you walk out of that divorce court or get your decree of divorce, make sure your will is amended according to your wishes. Once again, if there are minor children, who's going to be the guardian, what's going to happen to the funds, testimony trust, who's going to be the trustees, and so on. So yeah, that's also something. It's not just a divorce. You must look at your will as well after getting a divorce.
Interesting. So yeah, this is something that is very important. People must remember it. Then I wanted to hear from you. How long does it take usually to wind up an estate, and how much does it cost usually?
Taking into account winding up of the estate, there are unfortunately matters that's not in our hands. In some instances, I've managed to get a letter of executorship. That's the letter that the master issues, granting me permission to act as the executor in the matter. I got it within 6 weeks. I know of colleagues of mine that in some master's offices has been waiting for the letter of executorship for a year now. Now, the letter of executorship also, or the letter of appointment, that's when we get with section 18.3 estates, where the value of the estate is less than 250,000. That letter of executorship is the key to everything, because the executor cannot proceed rental sale agreements, policies that needs to pay out, all the insurance policies. They will ask, where's the letters of executorship? So the estate lies in limbo, respectfully, until that letter of executorship is at hand, and then it can be dealt with. Then you have some advertisements that needs to be placed, creditors, debtors. It has to lie for 21 days. So best case scenario, and this is very optimistic, 7 to 9 months. But if your lawyer is not able to wind it up in that time span, that's not to say that your lawyer or your executor is sleeping. They must just keep you abreast of developments. Like I say, the letter of executorship can take long to acquire that. Then with regards to costs, the administration of an estate fee is 3.5% of the value of the estate. Now, if we work on an estate to the value of 1 million rand, 35,000. Some expenses, I'm now talking about telephone calls, paper, ink, small things, that can easily amount to 3,500 rand just for that consumables. And then it's not taking into account the time spent drawing the papers, the L&D correspondence with the debtors and the creditors. So respectfully, 3.5% to wind up an estate, taking into account you as for instance, the widow, now try to wind up the estate yourself, touching that death certificate, copies of the ID. It's unnecessary burden. You know, it's some days it's his birthday, or it's the special day, anniversary date, and now that's the day when some of the creditors and the debtors will start phoning you for payments. So I will advise put it in the hands of someone that knows, because in the event of a liquidation and distribution account, how many of us normal citizens knows what is needed to properly prepare a liquidation and distribution account? And if the master is not satisfied that everything was done appropriately, then they will never let the estate be finalized. What's also costly in the winding up of a estate is not the winding up of the estate itself, it's where we get that there's immovable property that needs to be transferred. So that transfer costs, that's regulated by the conveyancing rules, that tends to be pricey, as well as if there's maybe a bond that still has to be cancelled, that can easily be 6,000 rand, depending on how many bonds are there over the property. So to make an assumption that to wind up an estate is costly, it depends from matter to matter, or the immovable property, and so forth. What I advise some of my clients is take out a small policy, something that costs you 150 or 200 rand a month for, say, 150 or 200,000 rand. Make that payable into the estate. Then immediately when we start winding up the estate, we know there's enough cash in hand, and at the end of the day, the surplus gets paid out to the heirs. So that's also options. Also, what sometimes happens, parties are married in community of property. So, for instance, the mother passes away. They don't think of doing anything because there's a house, the father is staying on. And then years later, 15 or 20 years later, the father also passes away. And now what nobody has thought about, now, because they were married in community of property, so for instance, there's immovable property, now they have to wind up their mother's estate as well as the father's estate. And that's a pitfall that people don't think about it. So that's something to, you wait, and then at the end of the day, you will not be able to wind up your father's estate if your mother's, who's predeceased, or vice versa, isn't attended to first.
So you mentioned executorship. So can you tell us, what does the executor do?
The executor either gets nominated in terms of the will, or if there's no will, then nominated by the beneficiaries. And the executor then has the job to obtain the letter of authority or the letter of executorship. He then deals with all the debtors and the creditors, make sure the advertisements are placed, make sure that redistribution is dealt with, claims against the estate, claims in favor of the estate. If there are other forms of income like rental income, deals with that. And then at the end of the day, make sure that all the legal requirements are met. Then the liquidation and distribution account gets finalized. That lists all the assets, the liabilities, the administration costs, and then at the end, it gives a breakdown of who inherits what. And then when every cent has been accounted for and the master is happy with everything, then the master signs off on that estate and then it can be finalized. A lot of admin work going into it, a lot of technicalities, set forms that has to be completed and submitted. At the best of times, before I went into practice, rewind 20 years ago, with the knowledge I had at that time, I wouldn't have even wanted to try to wind up an estate myself. I would have ran for the hills. It's not just something you can expect the normal person on the street to attend with. 18.3 estate, that's less than 250,000. That's much easier to try and wind up yourself because the technicalities like liquidation distribution accounts are not in play there, but it's still not the thing I think that someone that's still in mourning needs to deal with.
So, Maryke, then I wanted to ask you, I get a lot of people who tell me, I don't want a will, I don't need a will because I don't have a lot of assets yet. What would you say to those people?
Okay. Now you put off on getting a will. So you fall in love, you get engaged, you get married, there's children, no one talks about a will. Then something happens. Call out for work late at night, unfortunately, motor vehicle accident, nothing. Or even worst case scenario, both parents decide now we're going to get a weekend getaway, grandparents are going to look after our children, just break away, and then an horrible accident occurs. And then also, once again, throwback, marriage and community of property. The wife tends to look after the house, the children, cooking, cleaning, you know, the homely, motherly type. And the husband was the one working, buying a house and so, but that marriage and community of property. So the wife thinks, I don't have anything, I don't need a will. Now we fast forward, she passes away without a will. Everyone thinks, okay, she didn't have anything, so let's proceed. And now the husband passes away, and now it's this house that, due to the marriage being in community of property, registered in both names, to estate needs to be reported, transfer from the wife to the husband, and then from the husband to whatever his will says, or in terms of the Interstate Succession Act. So currently, I mean, even if you just want to let your Xbox go to your brother, make a will, start getting into the habit. Unfortunately, and it's bad to see it, the winding up of estates, especially if there's not a valid will in place, it breaks up families. Infighting starts. The eldest son believes he's entitled to the equipment in the garage. The eldest daughter thinks, okay, she's entitled to all the jewelry of the mother. The youngest son, who was looking after them, the elder children think, no, you were the little one, you got everything with a golden spoon, you're not entitled to anything. And that's how families, it's a mourning. They lost a family member or family members. And now there's no complete rules with regards to what does the parent or the parents want to do with the estate, and then infighting occurs. What I also would just like to mention is that when drafting a will, you can't rule from behind the grave. There are matters, the will in the matter of King and the Jager. the will stated that the inheritance should go to students of European descent and of the Jewish faith. Now, that matter ended up in court, and a ruling was made that this is discriminatory. And also, it then refers to the Islamic law, where a lot of that disadvantage with the way the inheritance usually works. So when making a will, you can't make something that is against the norms. And also, I know about the matter where the grandfather made the will, huge family farm, been in the family for generations, that he said, but the farm should go to the eldest grandchild. And when he passed on, the whole family had already immigrated, and the eldest grandchild didn't want the farm. So it was high court applications and documents. You don't want to know the amount of work going into it to prove that the grandson is not going to take up the inheritance. The farm needs to be sold. What's going to happen to the process of the farm? And what is the implication it will have on the heirs? So that's also, don't rule beyond the grave, and you can't just, that's also just things to, but that's once again, you need someone that's professional, that's got the know-how, just to guide you through these. Because, I mean, someone makes a will, okay, everything goes to students, European descent, Jewish. Then you are one of the grandchildren or family member. Now it's front page news. Mr. So-and-so made this type of wishes in his will, and that's unnecessary. And each to his own, but that's also one of the pitfalls that one can step into if you do not make sure that your will is in order and properly drafted, and that you are properly advised before drafting it.
I'm glad that you actually mentioned that, because my next question to you would have been, what can't you put into your will? So what are you not allowed to put into your will? But I think you already answered that question. So lastly, I wanted to ask you, as this podcast is called the Justice in Heels podcast, have you ever been in a situation where you were underestimated purely because you are female? And what advice would you have for other ladies who are facing a similar issue?
Danielle, indeed I have, but what I can tell you from the onset, if the case gets intricate, then the heels gets higher and the lipstick a brighter shade of red, and then we march forward. I attended to a matter where a friend of the potential client phoned in, making an appointment, divorce matter. And little did I know that when the client walked in the Friday afternoon, he was expecting to consult with a male person. And I learned very soon into the consultation that we would become set of attorneys number 3. And then he stated, well, he didn't want a female to attend to his matter. He prefers to have a male lawyer. And so that was a Friday afternoon. I wasn't on my best behavior. And so I told him, sir, with all due respect, your previous attorneys were both male. They didn't give you joy. This is what I propose. And then I set out a proposal to him, the way I would attend to the divorce matter, what I think would be reasonable, give a bit, take a bit. And so I said, well, if I were to get the instruction from you, that is will be my advice, we go this way forward, but take the weekend, sleep on it, think on it. If you don't want me, that's fine, it's your prerogative. If you do want me, come and see me Monday afternoon at 2 o'clock, then proceed forward. Oh, well, he attended the offices then Monday afternoon, 2 o'clock, started the divorce matter. And I'm proud to say, even the divorce has been finalized for so long, we still keep contact. He still taps in when he wants to know something. And when he first was opposed to me, due to me being a woman, I think at the end of the day, me being a woman worked to his benefit in concluding the divorce matter.
So what advice would you give to someone who's perhaps facing a similar issue?
In this current day and age, there is immense pressure on women. We are women in a man's world, unfortunately. There is a lot of male colleagues out there that does a lot to embrace us and to assist us. In this, and it's a hard work, the clients tend to be ungrateful. You work hard for your fees, you tend to accommodate them with fees, and at the end of the day, you feel like a beggar to ask for your accounts being paid in certain circumstances. Luckily, not all of it. But in this hard life, don't lose your sparkle. Don't lose your femininity. Fight with what you have to fight with. Fight the correct fight, the moral fight, and just go with it. Don't lose yourself, and don't lose your inner girl child. I'm referring to girl child because all of us still have that girl child in us. I myself have. I'm turning 46. Yes, I like to walk in the rain. I like to walk barefoot in the rain. I dance in my living room. Don't become hard because it's a hard world, and don't lose your sparkle that only you can have and that you can give. The world outside needs female litigants. They need female lawyers. And I believe some of our male colleagues also needs us out there, because the way that psychologically and everything, sometimes you just need that different button, the different view that I think that our women or our females can give, that sometimes the male, they are so used to being in this, go forward and everything that's in your way, you just, they need us in practice. And I believe our clients need us in practice, and also our female colleagues. We need one another, and let's put on the crown. If you see one of your colleagues, the crown is falling off, stop and just put back a crown on her head.
Love that advice. Thank you so much for sharing your story with us and also for educating us on this very important topic today. So where can our listeners reach you? Are you on social media? Do you have a website?
I'm on TikTok, but you can get me on Facebook van der Westhuizen Attorneys. My email address is legal, legal, @vdwestlegal.co.za, or you're welcome to drop a WhatsApp or an SMS, or please call me 061-849-6289, and then I would like to get back to you as soon as possible.
Thank you for listening to this episode of the Justice in Heels podcast. If you like this episode, we would love for you to share it with your friends on social media and tag us. As this is a legal podcast, here is a quick disclaimer. The views expressed in this podcast are solely the views of the individuals involved and not those of the firms, brands, or anyone else that we are affiliated with. Till next time.